In today's lecture, we're going to be looking at Chapter 6 of the text concerning prosecutors. So, much like with other aspects of the criminal justice system, the system we have in place for prosecutors comes from what we had in England. Um, they still there have what is known as private prosecution, sort of like a civil investigation, though individuals are more compelled to participate in those processes than they might be here in the United States. Um, the implication or application of private prosecutors has been removed for the most part. In a lot of instances, again, it's more of a moving towards a civil matter, sort of changing what we're looking at there. The main reason that this is an issue now is that the individuals that seek a private prosecution have to pay for it. And oftentimes that can be recouped in the outcome of the prosecution, but in a lot of instances it's not. So the access to private prosecution is very socioeconomically based. If you don't have the means to hire a private prosecutor, there would be no way to instigate the process. So the role of prosecutors, sort of in more modern times, they have very broad discretion. We've talked about that before. You'll see clips of that in the video link for this week as well. Though once the trial process is started, they cede a lot of the control over to the judge. Although at any point they can rescind the charges and end the whole process themselves. But once the trial process starts, a lot of the power then does go to the presiding judge. They have a lot of things they can take into consideration when they are making a decision on whether or not to prosecute someone. The blameworthiness of the person. Did their actions cause what took place? Is it in the interest of the community? And also, what are the sort of practical constraints with regarding bringing the charges? Is it on the books that what they did was a crime? What punishment could potentially come from this? All of those things have to be considered when we're looking at a decision whether or not to bring charges in a particular case. So the act of charging, the decision to do that is based on, number one, the seriousness of the offense, the strength of the evidence. So is it likely that a conviction is going to be achieved? Also, the culpability of the defendant. How responsible are they for what happened? And something that's changed in this aspect recently in the last 20 to 30 years, is how we look at cases of prostitution. In the past, the prostitute themselves were oftentimes vigorously prosecuted for their what were deemed immoral crimes. In modern times, we understand that the prostitutes are oftentimes the victims in these instances. They are addicted to drugs intentionally on the part of their pimps. They are made to perform sex acts that they would not otherwise do, even if they're being paid. So we've sort of re-examined what the culpability is in a lot of those instances of those offenses. Something that is needing a re-examination is with drug crimes. Drug addiction is a public health issue. The criminal justice system has tried and failed to combat drug addiction. Yet we still bring these criminal charges against people who are basically physically compelled to intake the drugs when we're talking about things like opioids. Also, the degree of harm that was done is very important in the decision to charge or not. Sort of what outcome based, not the most important thing, but it is a factor. Also, the cooperation of the defendant. Are they participating in the process? Something like a traffic accident. If you're driving along the road in absence of someone being intoxicated, say you're sober, and someone walks into traffic and you hit them, if you cooperate with the investigation, there's probably not going to be any charges. Again, barring any sort of intoxication or fault on the driver, using your cell phone or something stupid like that. But if that same thing happens, and the person drives away, well, they're not really participating in the process. They're evading the process, and you can be charged with a felony. Again, it really just depends on what circumstantial situation is going on. You also have the issue of likelihood of prosecution by another jurisdiction. So we talked about how courts, there can oftentimes be multiple courts that have jurisdiction over a particular case. If it's likely that another jurisdiction will and wants to handle a case, sometimes they will allow that to happen. That happens a lot in death penalty cases. It can really go both ways in death penalty cases. If a particular jurisdiction doesn't want death penalty to be implemented, they might take the case themselves as opposed to letting another jurisdiction try the case. It really just depends again on what's happening in the particular circumstance, whether or not who's going to either try to take jurisdiction or who's going to try to give up jurisdiction. We also have the much like all the the policing system that we have and the court system in general. It is fairly decentralized in the United States compared to the English counterparts. The English system, everything's pretty much under one court system over there. Here we have, 8,000 different prosecutors' offices between the local, county, state, federal level. Very different court structure in all 50 states. Potentially different charges, different definitions for crimes in those 50 states and the federal government. So it makes it very difficult to really pin down exactly what a prosecutor's office looks like in one particular instance. At least at the local and state level. When we talk about the federal courts, it's much more centralized. It's much more uniform across the entirety of the system. You have the U.S. Solicitor General, a very high position in the government, basically handling the government's stance in federal court cases. So someone sues the federal government, or if there's some other aspect where the government wants to issue an opinion about something, it's done through the Solicitor General, as opposed to the Attorney General, which is an appointed position as the head of Justice Department. The U.S. Solicitor General is more hands-on in the courtroom position than the Attorney General. As far as the U.S. attorneys, they are you typically have one for every district in the country. 93, those individuals are the highest ranking law enforcement official in those jurisdictions. They overrule local ASACs, which is Assistant Special Agent in Charge for FBI, DEA. They are the highest ranking federal law enforcement official in the area where they are in those districts. Local courts, you have state's attorney general, typically one per state. That's oftentimes an elected position. I don't know if there's any states that haven't appointed. It'd be appointed by the governor. I'm not sure how that works in every state. They are seen as the top attorney in the state, much like the district, the federal district attorneys are the top sort of law enforcement official. The state's attorney general is usually the top law enforcement official in the state. Other smaller jurisdictions could have a chief prosecutor, district attorneys, really just depending on what the needs are for a particular area. Within those district attorneys or district court offices, you're going to have subordinate attorneys that are going to be the ones that are handling the majority of the trials. In a district attorney's office, so we'll look at, say, Fulton County, for example. We just hired a new district attorney, Counselor Williams, Judge Williams, now District Attorney Williams, is the new district attorney, and so I would imagine there's going to be a fair amount of new assistant district attorneys that are going to be hired, because the last district attorney, who was just ousted by an election recently, is not looked at favorably in the new district attorney's eyes. Paul Howard is still currently being investigated by the GBI as well as various federal agencies for wrongdoings done during his 20 plus years as Fulton County District Attorney. So it's going to be one of those moments where you have that sort of political political reformation affecting the attorney's office. It's basically learning on the job, much like being a. They don't really teach you how to be a police officer in the police academy. You don't get to be. You're not taught how to be an attorney in law school. They teach you about the law and how to think, and then you're thrown into the wolves to learn how to file motions, how to handle office politics, how to handle courtroom workgroup politics, and basically just sort of learning on the job, failing forward. A lot of promotions, unfortunately, in the district attorney's offices are based solely on conviction rate, which is the shittiest metric you could use for determining if if an attorney is doing their job well. Basically, can you hammer people into pleading guilty? Yes or no? It'd be as if you were trying to determine who the best quarterback in the National Football League was by which of them could kick the ball the furthest. You're taking an aspect of the job that may come up. You know, how frequently someone convicts someone. Sometimes a quarterback's going to have to do a drop kick, but it's not an important aspect of it. It shouldn't be allowing not bringing a case to prosecution or dismissing a case should not negatively impact the career prospects of a potential district attorney or an assistant district attorney. Unfortunately, that's what happens. There is some supervision, although it's a lot of times the district attorneys or assistant district attorneys, ADAs, are allowed to operate fairly freely if they're doing their job well. They're not having a lot of complaints against them. But there has been an effort to try to have more review over this process, citizen review, much like with the police system, just to see, really how these decisions are being made, who's making these decisions, who's benefiting, who's being harmed by this process. So again, that's an aspect of the system that's trying to have some change. Much like with we talked about before, where there's a lot of ethical issues that come up for the different actors in the system, prosecutorial ethics are very important because they have so much discretion. So their ability to bring charges or not to bring charges is very important. And with that is the idea of prosecutorial immunity, where prosecutors cannot be criminally or civilly charged for wrongdoing that was unintentional. But I feel like there's a new coming debate about what is intentional and what is not, and you see some of that in the video for this week. There have been very, very, very few prosecutors that have ever been charged with misconduct. According to the video, only one has ever seen jail time, and I believe the individual served less than a week. So there is a lot of leeway that prosecutors have and have enjoyed in the past. And if we're going to really re-examine with scrutiny what type of discretion police officers have, we really need to do the same thing with other actors in the criminal justice system that work on behalf of the state. So like I said, they are part of the courtroom work group. They have to work with the judges. They can't just do whatever they want, or they can't bring frivolous charges. Judges are going to take offense to that. They're in kind of a power share mode with judges before the trial and then during the trial. So it's very important that the prosecutors and the judges have a very good working relationship to be able to work together in the next day. They also have to have the same sort of relationship with the defense attorneys, although the defense attorneys are oftentimes fairly beholden to the actions of the prosecutor, what they want to do in a situation. But at the same time, they have to have a level of operational respect for one another to be able to do their jobs. Similar issues with the defendant. Oftentimes, the prosecutor and the defendant don't really have a relationship other than through the defense attorney. But if they see sort of repeat customers, they really sort of need to look at why these people keep coming back, as opposed to trying to punish them and punishing them harder each time. That is sort of an issue in terms of, because the prosecutors have so much power in the situation, their role in the courtroom work group can be very, can kind of be on shaky ground or thin ice. because at some point, if they're not getting what they want out of a situation, they have the power to basically force their position on other individuals in the courtroom work group, especially defense attorneys and defendants. And because these positions are elected a lot of the times, district attorneys, we saw this recently in Atlanta where Paul Howard brought charges against two Atlanta police officers for an officer-involved shooting, uh, what turned out to be months before the GBI finished their investigation on the case. Now, that information has not been released. We don't know what recommendation the GBI has made, but a prosecutor bringing charges before police have a chance to gather evidence is not the right order things should be done in. And that happened exclusively because the district attorney was in a contentious race for his job, which he lost. So the political influence has always been an issue, but people seem to be smarter about sort of smelling when that's happening and reacting typically not in a way that's seen as positive by the person engaging in the politicized prosecutions. Additionally, prosecutors have to have a professional relationship with the police. Now, that does not mean that they are working on the same team at the same goal. The police investigate and bring the evidence that they collect to the prosecutor. The prosecutor is supposed to serve the interest of justice. Their job is not to seek a conviction and to get a conviction and to have the high conviction rate. The prosecutor's job is to seek the interest of justice. If the interests of justice say that a case should not be prosecuted for whatever reason, then they should not prosecute it. There are legal and moral, ethical issues arising in those situations. But the prosecution and the police are not, in the same batting lineup on the same baseball team. They are supposed to be separate aspects of the criminal justice system, but the overfamiliarity that they have in this drive to prosecute people in a crime control model makes it seem like that. And when a prosecutor then has to bring charges against a police officer, it makes it extremely awkward to try to work together on the next case. So there needs to be a recalibration of the relationship and role that prosecutors and police have working with one another in the early stages and then through the trial process on cases. Because the system that's set up right now, at best, has tendrils of being unfair, and at worst is blatantly sandbagging defendants. So be sure to watch all the other lectures for this week. Read the chapters, and then we'll move on in the next part to looking at other individual courtroom work group members.